important to consider when asking for that in the event of an electronic discovery dispute and a question concerning lost or destroyed evidence. One, so the baseline inquiry for the judge is always whether or not that information is relevant and admissible to the issues before the court. And the second is the question of whether or not there was an intentional or bad faith instruction. Both of those issues state court judges are required to look at before the negative inference instruction can be given. These issues that I'm going to discuss for just a moment were not my outline, aren't necessarily part of electronic discovery disputes, but I think it's important because we see this on a fairly regular basis that evidentiary questions concerning the use of electronically stored information tend to be more prevalent in state court than even disputes concerning the discovery of electronically stored information. I can't tell you how many times I have had to, in protection order cases, for example, decline someone's cell phone as a piece of evidence because they don't have a complete understanding that if they offer the texts on the cell phone, and the cell phone itself is what they like to offer for me to review, that I need to then keep the cell phone and use that for purposes of the record in that particular case. So I urge you to take a look at authentication issues under Rule 901 and 902, and looking at use of electronically stored information as you proceed to state court. One of the things that I look at in terms of a dispute concerning electronically stored information is whether there is the use of that information at the time of trial, and whether or not we have some concerns concerning evidentiary issues, because those matters can be looked at by the court when making some determinations as to relevancy, cost shifting, and whether or not there's a burden that is imposed upon the parties from whom the discovery is being requested. So the urge that I give you as we move forward in electronic discovery disputes in state court is to suggest to you that you take the opportunity to do two things. One of which is to educate your judge early on about the technological components that are necessary and will be looked at in your particular case, and two, put into plan, or put into place, I should say, a plan that can be used as part of the discovery process in your case, so that judge has an opportunity to work from that plan and resolve disputes consistent with the types of things that should be in your plan, including the timing of your discovery, the format in which the discovery is going to be released, the custodians from whom the discovery may be sought, the number of individuals, for example, who may be imposed as part of electronic discovery issues, what's going to happen as it relates to privilege or inadvertent waiver of privilege questions, and the anticipated evidentiary use of the materials to be sought at the time of trial. If those things get put into place before the dispute arises in the state court, it makes it significantly easier for those of us who are more technologically challenged to address your question. Gathering aside, I'll let you know that the state court system is moving forward with electronic filing and have some, and are moving into our current century in terms of some of our technologies. As recently as within the last year, changed dictation system from microcassette to digital. So we have some understanding about where we're at on the technology curve. So keep that in mind as you move forward in discussing ESI issues with your state court judge. Thank you.
At this time, I'm going to invite Bob and Colleen back up to the stage, and we're going to start our panel discussion, which really is mostly just going to be a question and answer time. So if you have a question for anyone that spoke today, please get my attention, Megan's attention, or Judy's attention, and we'll go ahead and have our speakers do their best to address the questions. While you are thinking about your questions, I'm going to kind of dovetail off of what Judge Fifley just talked about and ask our experts here what might be the best way in a case where we're dealing with something like a text message any other form of litigation that may have some cost prohibitive issues with hiring an expert, what can the attorneys do to preserve that evidence and submit it to the court in a way that would not create foundation issues?
When you're talking about cell phones and trying to get the data off of a cell phone, depending on the type of cell phone, and Colleen can certainly talk about this as well, it can have actually some pretty substantial costs, just simply because you would think that it's easy to get data off a cell phone. It's not necessarily all that easy. But there are different ways that you can do it. If you're using it from an admission against interest perspective, obviously that doesn't even get to the hearsay question. But from a foundation perspective, we need to talk about the chain of custody and authenticating that it actually came from the user. And that can sometimes be the difficulty from the standpoint of laying the foundation or linking that message to the purported author. Now, and that's why, for example, in the Campbell State case, which is out of Texas, they use distinctive speech patterns in on Facebook posts to link that communication back to the purported author. But other ways that we can do it is, depending on the wireless provider, if you just want the messages themselves, frequently Verizon will maintain the text messages themselves for a short period of time if you're a recipient of the text message or your client is a recipient of the text message. Getting Verizon to produce that data is, somebody else is not probably going to happen because they resist subpoenas for that very vigorously.
Our office, we deal with cell phones all the time. We use what's called a universal forensic, it's a UFED, let's call it that. It's similar to what the law enforcement uses when they pull data off of the cell phone. That's one of the expensive options that you can go down if you're looking for more than just text messages. I've heard of different ways that lawyers do it to try and be more cost effective, depending on how you're going to use the text messages and if you're going to, see some resistance from the other side. If they're going to say, I never sent that text message, I don't know what you're talking about, or if they're going to stipulate to it, I think that's where you're going to run into some issues. I've heard that a court reporter may come in and look at the text message, type it out, type in the pertinent information like the data was received, the phone number that's on there, and then a good way to kind of tie it together is get information of who that phone number was subscribed to. That way you can link it back up to another account. So it's a matter of what you're going to see from the other side, if they're going to oppose it or if they can stipulate to it. Or we've got the capability of pulling the data from the phone itself. A lot of times we'll draft an affidavit to say that it is what it purports to be. Sometimes we'll pull in additional stuff where you can log into your client's Verizon account and you can match it up to the received and outgoing text messages to show that it hasn't been fabricated on that phone, to show a couple of different things. But again, sometimes we live in a little dream world in our box thinking that we're doing the right thing. I would love to hear from the judges what they would like to see at the end of the day.
Well, with regard to text messages, I usually have seen them in criminal cases. And normally the text messages would be typed out with someone verifying that they had actually typed what was on the screen. And then the U.S. Attorney's Office is able to get the provider information from Verizon, whoever the cell phone provider is. I haven't actually seen text messages in a civil case, so I don't have any advice for civil attorneys on how to handle that part.
I will indicate that I rarely concern myself with hearsay issues as it relates to text messages because, generally speaking, the message itself will fall into one of the 26 known exceptions to the rule against hearsay. But what happens in most cases, if you have actually murder cases, for example, which I see a lot of this particular issue, is I request that the parties have the opportunity to review the phone upon which the text has been placed, that we take the opportunity to have a discussion about whether or not there's going to be an issue as to authentication of the message itself, and then generally speaking, the message itself is going to be read into the record in terms of the number from which it came, time stamp upon which it was dated, and then the context or the content of the message itself. I have had other circumstances in criminal cases in which text messages have become an issue. In most of those cases, law enforcement has been able to gather those records from the service provider. There's been sort of a format in which the message itself is a timestamp, the number from which it comes has been given, and it's put into a spreadsheet type format, and law enforcement officer will then authenticate that that's the result of the subpoena or order of the court. So in those circumstances, it works. I think there can be circumstances in which the cell phone itself has to be received into evidence and taken by the court if there is an issue as to concern about authentication of the message itself. But I would urge you to take the steps as early as possible in your case to make sure that the text message authentication is going to be issued, that you do that. Frankly, it can be as simple as a screenshot of the message itself. That screenshot has some identification as to the number, the date, and time, and the individual who has custody of the screenshot and then testify that it is what it purports to be, and under the authentication rules, that should be sufficient. But just something to remember as each case moves forward.
Kevin.
When you're talking about an adverse instruction in federal court, are you also talking about a permissive instruction that allows the jury, or are you actually instructing the jury to make it?
Well, the example that I gave you of the train case, in that instance, the jury instruction that the trial court judge had given actually said that he found that there was intentional destruction, and that as a result of that intentional instruction, the jury could draw the adverse inference. And that instruction was similar to the one given in the other train case that was affirmed. And the court didn't talk about whether the instruction itself was proper. So I think in federal court it can be a direction that bad faith has been found, or it may be a direction that the jury could find bad faith. In most instances, when an attorney has requested an adverse inference instruction before me, they usually propose the South Dakota pattern jury instruction, but I'm not required to follow that instruction because I apply federal law. But if they haven't proposed one that says the court has already found bad faith, I'm not going to insert that language on my own.
The I
noticed that the language of that proposed rule starts
out by saying, there we go, starts out by saying that it applies to information that should have been, like, question or you know?
I don't know. I think when they talk about should have been preserved, though, that they will go back to the prior case law on what has already been described as should have been preserved. The one really open question I think exists is whether that rule is the exclusive rule that the court can grant sanctions under, or if we still have the whole panoply of other sanctionable areas, and I think that that'll be fought out in the courts for a while into the future.
Does anyone else have questions for any who are again? If you would stand back in the back.
My question has to do with the comment that Colleen said about opening up. When you ask somebody to search, and where we go to our clients and we say, we have this discovery request. What do you have that's relevant? And you said, be careful when they open it up and they might change the metadata. My concern is, what are we supposed to do to prevent them from changing metadata? Because they have to open up the files to see what they are, to see that they're relevant, so they can provide it to us as attorneys. So if you have any suggestions for that, I'd like to hear it.
Okay, I think I got your question. I'm going to restate it so everyone can hear, and then I'll go forward. Her question has to do with preserving the data and the simple opening up of a document, changing that metadata. And she said, well, how is my client supposed to know if it's relevant without opening it? It's a good question. Is that kind of, and then what steps can you take to prevent that from happening or instructing your employee? Or
Well, they have to open it. So what can I tell them to make it safer for them? Because that's the only way we're going to get to electronic information. What can I tell them to be careful about?
well, that's where the self-help is a problem. If you've got a case where date and timestamps and metadata is a big deal, I would suggest collecting first and then going and seeing what's relevant and responsive. Because, I mean, you don't want a document that's been sitting dormant since 2006 and has been, sitting in a folder within a folder within a folder that no one's touched. And then all of a sudden, they've been asked to send these documents over, and date and time is an issue. And all of a sudden, just because your client went in and opened up that document, it could change the metadata and say that they've accessed it in 2013. And that would change the story and the context of that specific document. So in a case-by-case basis, you need to consider whether or not metadata is an issue. If it is, then I'd recommend if you're dealing, trying to instruct your clients, I'd talk to an expert and figure out how to targetedly collect a broader amount of data, so then you can go in afterwards and review it in a very safe and forensically sound manner, so you're keeping that metadata intact. Does that kind of answer your question?
Yes, thank you.
And the process that Colleen is talking about is sort of technically referred to as mirroring. And you can mirror the whole hard drive, you can mirror a whole hard drive, or you can vary the ability so you can mirror portions of a hard drive to just collect certain data from that standpoint. And the mirrored data will then preserve that original metadata that you're looking for, especially if the access date is going to be very important. If the access date is not necessarily something that's going to be important, opening it from a read-only perspective will usually save the biggest issue, because frequently when you're dealing with metadata, the one issue that you're really concerned about is the last edit date. And that is something that certainly if you open it up and you accidentally save it on closing, that can affect that. So.
And one last thing, my biggest thing when I was speaking earlier was document everything. If you're unsure if metadata is going to be an issue, and you think you've preserved, and then you're going in to check whether or not something's responsive, make sure you're dating when you're going in and looking at that document. So if in the future that date becomes an issue, you can say, I've documented that's when my client or my employee went in and accessed that document, and it was for that purpose, was to see if it was relevant. So again, documenting and making sure that you're doing a reasonable step. You can be able to explain it away in the end.
Is there another question from the audience?
Do you have any examples of an attorney being sanctioned under Section 1927 for vexatious conduct?
I don't know of any in South Dakota. If you go into the statute and the case annotations, there are instances there, but I'm not aware of that being used in South Dakota.
the back of the outlines and fill out the survey for the CLE. And if you do end up having any questions for the presenters, I know they would all be happy to answer things either in a few minutes following the presentation, or if you would like to contact them at a later time.
And that's a wrap.